The U.S. Supreme Court heard oral arguments today on two challenges to Texas's pro-life heartbeat law, which abortion advocates oppose as a challenge to Roe versus Wade. Take my heart for what breaks yours. Today's arguments considered whether abortion providers in Texas or the U.S. Justice Department are legally able to challenge the Texas law, which the High Court has twice allowed to take effect. Let's bring in Carrie Severino now, president at the Judicial Crisis Network. Carrie, welcome back. Great to see you. So after about 3 hours of arguments today, tell us, what was the result?
Well, I think the results may be different in the two cases the court was addressing today, but it's very hard to predict, particularly because on these cases, we're really talking about these intensely procedural questions. This case is not the one that addresses just the fundamental question of, is Roe versus Wade, our Planned Parenthood for Casey, good law? This has to do with the procedural intricacies unique to this Texas heartbeat bill. And so it's a little harder to predict. The first case is the original case brought by abortion clinics, Whole Women's Health and others. And there's the question of whether that one can proceed, and then also the Department of Justice case brought by Attorney General Merrick Garland. I think the read is clearer on the second one. That one, the court seemed very concerned about the real stretch that AG Merrick Garland is making in this case, trying to find some way to bootstrap their way into being able to bring a case just because they say this law violates the Constitution. I think they were very skeptical of that. It's possible, however, in the other case, the justices may find a way, maybe by changing slightly some of the procedural questions of who can bring these cases, simply because I think they're so frustrated that this law seems designed to circumvent pre-enforcement judicial review.
And Carrie, was there anything that really stood out to you today from the oral arguments?
Well, it's always great in this sort of new era post-COVID to hear some of Justice Thomas's comments, because he's been really active in oral argument. And he had actually some really serious questions for both sides. So that was wonderful to hear. But again, I think one of the things that really struck me is that the court really recognized what a stretch this politicized Department of Justice had made in this case. And the other thing that really brings home is that if the Supreme Court can't find a way to decisively and clearly answer the outstanding questions about whether Roe and Casey are good law when they hear the Dobbs case in December, this is the kind of case that's just going to be coming back and back and back. And we all know the Supreme Court justices hate to be in the crosshairs on this. They hate to have to make these high-profile third rail kind of decisions. I would say, if you want fewer of these Texas cases coming up, I would really consider having a very clear and decisive guidance to the lower courts in the Dobbs case to make it clear that Roe and Casey are unconstitutional.
Carrie, the court, as you know, currently uses viability as a standard for abortions. I want to talk about, how does the United States versus Texas case, how does that challenge the standard? What can you tell us about that?
Well, this one goes not even just to the viability standard, because Texas already prohibits in the more normal course of action just by saying this is against the law and will prosecute you if you do it. They prohibit post-viability abortions. This law was really designed to go beyond that, because the heartbeat, obviously, as we all now know so well from discussing this case, can start as early as 6 weeks. And so this completely flies in the face of the viability standard. So if the court is ever to get into this case to the merits of it, they would have to squarely say, okay, either Roe and Casey are good law, or and we're going to strike this down. If you're going to uphold a heartbeat bill, you simply have to acknowledge that Roe and Casey have no grounds in the Constitution. That said, because of all of the procedural layers on this case, there's no way they're going to get to that now. Today's argument was really just addressing who can sue. Can anyone sue at this stage to challenge the law? Or do you have to wait for someone to perform an abortion and then someone to bring a lawsuit against them, which is frankly how most constitutional provisions are addressed. And so that was the state of Texas's response. Is just look, wait, and we'll have a lawsuit that is brought under this law, and then you can squarely address those questions of again the state challenging the viability standard head on.
Well, Carrie, unfortunately, we have to leave it right there. So much more we could talk about, but we appreciate your time. Carrie Severino, president at the Judicial Crisis Network. Thank you again.